welcome to this subject in Constitutional and Institutional Law of the European Union. This course aims to provide you with advanced knowledge of the constitutional framework of the European Union. You'll enjoy studying the constitutional and institutional law of the EU if you like politics, if you're a pragmatist, if you're interested in law beyond stereotypical classifications. First and foremost, the study of the EU constitutional framework is more topical than ever before. The EU is at the forefront of the most intractable problems of our times: the Eurozone crisis, the refugee crisis, climate change, Brexit, issues that challenge modern economies and societies. The constitutional and institutional law of the EU is a very dynamic field, driven many times by the judgments of the Court of Justice of the EU. Indeed, the Court of Justice is often considered an activist court, giving surprising rulings which push back the frontiers of the law. European integration has been driven equally by member states as well as the court, which has contributed extensively in filling in the gaps of the EU treaties by explaining in a pragmatic, yet integrationist manner, the broader aims of the EU, for example, the creation of a functioning single market. EU law is unlike anything you have studied before. Whatever types of law you may have liked before, such as public law, private law, economic law, human rights law, EU law doesn't fit into any single category. In this context, this subject will help you understand what is the European Union, how it functions, what are its mechanisms for producing law, how national law interacts with European Union law, the system of EU judicial protection, and the landmark cases decided by the Court of Justice of the EU, and the basic principles guiding EU integration. As most LLM postgraduate subjects, this subject is comprised of 4 different parts. Part A introduces the institutional outline of the European Union. This part examines the history of EU integration, identifying key milestones so far, and the forces and circumstances that gave rise to them. In so doing, it identifies fundamental issues concerning the EU constitutional order, such as the very controversial and topical question of the legitimacy and democratic deficit of the EU, or the broad scope of EU powers, and the principles underpinning the balance of powers between the EU and its member states. Moreover, this part looks into the institutions of the EU. Many students don't find that the most exciting part of the course. Yet, understanding EU institutions is crucial to obtaining a knowledge of the functioning of the EU legal system. It's the Commission which comes up with legislative proposals. It's the European Council where much of the power lies for important matters and decisions. And it's the European Parliament which has a final say on most legislation together with the Council of Ministers. Part B examines first the sources of European Union law, the EU treaties, and the various forms of EU legislation, including regulations, directives, and decisions. By examining the role and nature of different sources of EU law, you can understand why, when, and how laws are adopted at EU level. Identifying the sources of EU law relates also to the second key theme of this part, which is about the relationship between EU law and national law. Consider the headlines in newspapers across Europe stating how Brussels dictate member states what they can and cannot do. This part examines the basic principles of supremacy and direct effect which guide the relationship between EU law and the domestic legal orders of the member states. Part C introduces the system of judicial protection under EU law. It sets out the general remedies and procedures that are available. We look into the different types of actions available for assessing the legality of both national member state measures and EU measures. We examine who can bring an action? For example, the European Commission, other EU institutions, member states, private individuals. Under what conditions? What measures can be challenged? The remedies that are available, and the grounds that can be relied upon. This part is particularly exciting, as judgments of the Court of Justice look different to those of both common law and civil law courts. Considering the type of action, the Court of Justice has atypical functions. For example, if the case is a preliminary reference, whereby the Court of Justice answers questions from a national court as to the meaning or the validity of EU law, the EU Court of Justice only interprets EU law, leaving to national courts the task to apply that interpretation to the facts. Finally, Part D looks at the main substantive principles of EU law, including human rights, citizenship, the rule of law, and proportionality. Human rights have gradually become a core element of EU law, especially since the adoption of the EU Charter of Fundamental Rights. The Charter has been used to assess the legality of provisions of EU law and to a large extent of national law, especially when member states adopt laws that fall within the scope of EU law. In that context, EU human rights norms have had a tremendous effect on the interpretation of European Union law, thus playing an important role in ensuring that EU institutions and member states alike respect the rule of law. Another key principle of EU law that is examined in this part is EU citizenship. Everyone holding the nationality of a member state is also a citizen of the European Union. But what does that mean in practice? Does it have merely rhetorical value? Or does it in fact give substantive rights, such as a right to be equally treated in work, or claim benefits in another member state? Is this a field into which the EU should have stepped? Has this fanned the flames of Euroscepticism? Or is this in fact the logical consequence of an ever closer union among the people of the EU? These questions remain today as exciting and topical as ever before, and this subject could be key for understanding them. Thank you.